Your Honor, he went in and took her by point back to the cooler and assaulted her there.
You did not kill her that day. You killed every dream she ever dreamed.
The court posed affirming the sentence of death to elect by electrocution by the procedures required by law.
On New Year's Day 2020, Jamal Ryan Smith, then 19, set off a violent series of crimes that shook Spartanburg County, South Carolina. Authorities say it began at a Domino's Pizza, where he forced a manager into a cooler and sexually assaulted her. Minutes later, he crossed the street to a fitness center and attacked another woman, committing a second assault and kidnapping. Later that day, Smith targeted an Advance Auto Parts store and then carried out a home invasion, all within roughly 6 hours.
Your Honor, he went in and grabbed the manager, the person behind the thing, took her by point back to the cooler and assaulted her there. All these happened starting at 1:10 p.m. and finished at 6:47 p.m. I've never seen 4 cases like this in such a close proximity, so serious.
Investigators connected him to each scene through surveillance footage and DNA collected from the victims. He was arrested the following day, still wearing the same clothes, caught on camera.
Mr. Smith, you've got 26 charges today. I'm going to explain each charge and what the penalty could possibly be.
When Smith appeared before a judge, he faced 26 charges, including kidnapping, burglary, robbery, and multiple counts of sexual assault, crimes that could keep him in prison for decades. In court, one victim spoke of living with the trauma for life.
He placed the gun to my head twice. I have 3 children and I did not know whether or not I was going to make it back to them. This is something I have to live with for the rest of my life. It's something that she has to live with for the rest of her life as well as the other victims, and we should not have to look over our shoulder every time we go somewhere.
Another victim's parent read a letter condemning his actions.
We don't hate you. We don't feel sorry for you. You knew what you were doing. You invaded our daughter's body. You had no right. This is unacceptable, and we despise you for this.
The judge refused to grant bond, citing the seriousness of the attacks and how close they were to where Smith lived. In February 2022, he pleaded guilty to charges including first-degree criminal sexual conduct and robbery, receiving a 30-year prison sentence without parole and permanent placement on the South Carolina Sex Offender Registry. Former NFL star Chad Ochocinco Johnson walked into a Florida courtroom in 2013, hoping to avoid jail time for violating probation tied to a domestic violence case involving his then-wife, Evelyn Lozada.
Are you satisfied with the assistance of your attorney?
He's awesome.
Okay. You should be. He's an excellent attorney. He did a great job for you, sir.
He had worked out a deal with prosecutors that would extend his probation, require more counseling, and let him stay free if he kept up with community service. As the judge praised his attorney's work, Johnson, feeling relieved, gave his lawyer a playful slap on the backside, the kind of gesture common on the football field, but wildly out of place in a courtroom.
Mr. Johnson, I don't know that you're taking this whole thing seriously. I just saw you slap your attorney on the backside. Is there something funny about what's going on here today?
I didn't laugh. No, ma'am.
But the whole courtroom laughed because you just slapped your attorney.
The lighthearted pat drew laughter from people in the room, but the judge was not amused. Seeing the giggles as a sign Johnson wasn't taking the case seriously, she tore up the plea deal on the spot.
I don't think it was done as any disrespect to me.
The whole courtroom was laughing because he just slapped you.
I don't think he meant to get a reaction. I know.
This isn't a joke.
I didn't do it as a joke, ma'am.
Everybody in the courtroom was laughing. I'm not accepting these plea negotiations.
Declaring, "This isn't a joke," she sentenced him to 30 days in jail, more probation, community service, and extra counseling. Handcuffed immediately, Johnson apologized and insisted he hadn't meant any disrespect, but the damage was done.
One could say that she overreacted because he did apologize, and in my opinion, he showed remorse. However, the judge might have been frustrated by his behavior, by the fact that the courtroom erupted in laughter.
From his cell, he sent a message to his fans, promising love through good and bad, a final nod to a moment that turned a minor court appearance into a very public lesson in consequences. Carantres Lamar Kennan, a 20-year-old corrections deputy with the Shelby County Sheriff's Office, came under scrutiny when allegations emerged that she had inappropriate contact with an inmate. The accusations surfaced in January 2023, leading to an internal investigation that quickly turned criminal. Detectives built a case that led to a grand jury indictment for unlawful contact with a prisoner, a Class E felony in Tennessee. After she was formally charged, Kennan was fired from her job and booked into jail, trading her badge for a mugshot.
State of Tennessee versus Akira Jones, set for Bonnie Raymond, first setting, out of custody.
Good morning, Ms. Jones. You've been indicted in a one-count indictment for sexual contact with prisoners, Class E felony.
After news of the allegations spread more widely in May 2024, a federal indictment was unsealed, charging Kennan with acts with a ward, a much more severe federal offense carrying a possible 15-year prison sentence. Kennan soon pleaded guilty. On June 30th, 2025, the U.S. Attorney's Office for the Northern District of Florida announced she had been sentenced to 1 year in prison, followed by 5 years of supervised release. In June 2024, Kyle Rowley was involved in a violent confrontation outside the Montgomery Inn Boathouse in Cincinnati after a minor car accident involving his brother and an elderly couple, Doug and Lois Morrow. Witnesses said Rowley attacked the couple during the argument that followed. Both were knocked to the ground. Lois Morrow suffered a serious injury, and Doug Morrow was also hurt. The disturbing footage of the fight quickly went viral, sparking outrage in the community.
Are they conscious at all?
I see the man standing up. The woman is still laying on the ground, and I think she's bleeding. She hit her head very hard on the parking lot.
Originally charged with felonious assault and 2 counts of aggravated assault, Rowley later accepted a plea deal, pleading guilty to 2 first-degree misdemeanor assault charges instead.
Do you understand that by entering into this plea agreement, you are voluntarily waiving all of those constitutional rights and you're not going to have a trial at all?
Yes, Your Honor.
It looks as though the parties have come to a plea agreement and that Mr. Rowley is prepared to enter a plea to counts 2 and 3 of the indictment as amended to assault misdemeanors of the first degree.
Rowley apologized in court, and the Morrow family agreed to the plea to bring the case to a close without a trial.
Your Honor, I will just tell you for purposes of the record, and I know that we discussed this in chambers, when our office received this case, we did meet extensively with the victim's family. They are in agreement with this resolution. We've had regular contact with their victim's representative, and so they have been fully informed, are in agreement, and would like to see the case resolved in this fashion. We are requesting that sentencing be set out so they have an opportunity to provide victim impact statements.
In February 2025, a Hamilton County judge sentenced him to 3 years of probation, 200 hours of community service, and ordered him to pay over $8,000 in fines and restitution. 18-year-old Maurice Verotto found himself at the center of an unusual scam that rattled an entire neighborhood in Dania Beach, Florida. According to investigators, Verotto created fake car rental ads on Facebook Marketplace using photos of his neighbors' vehicles without their knowledge. He would collect deposits from unsuspecting renters online and then send them straight to his neighbors' driveways to pick up cars that were never actually available.
People have complete strangers coming to their home saying they're here to rent their car, having no idea who this person is. The person that's going to the home having no idea they're about to find out that they've been scammed.
One neighbor said strangers kept knocking on her door, insisting they'd paid for a rental, while another family's car was damaged when a confused renter confronted them.
What's their reaction when you tell them my car's not for rent?
I don't think they believe me.
I didn't even know you can rent a car on that Facebook app.
Didn't he think that if he got caught, he's going to go to jail for a long time?
As the complaints piled up, deputies tracked the scam back to Verotto by following digital clues, subpoenas, and search warrants revealed links between his fake Facebook accounts, email addresses, and payment records. When deputies arrested Verotto, he admitted to setting up fake profiles and keeping backup accounts ready in case Facebook shut him down. He's now facing 13 charges, including fraud and theft tied to the bogus rental scheme.
I was just trying to see if he could get a lower bond because I really don't have it like that.
Is there anything else that you'd like to share?
No, Nothing else, that I'm just sorry for everything.
His mother pleaded with the judge to lower his $50,000 bond, saying she couldn't afford to get him out of jail. Meanwhile, investigators are still sorting out just how many people were tricked. The case has put a spotlight on the rise of Facebook marketplace scams in South Florida, serving as a warning to anyone who thinks an easy deal online is always what it seems. In May 2021, Tess Roland, a reporter at the time, was on her usual route to work when a drunk driver, Jacob Savage, crashed head-on into her vehicle. The collision left her unconscious and fighting for her life. She woke up in the hospital to learn she had suffered devastating injuries that would require multiple surgeries and months of painful rehabilitation.
She has 4 massive scars. She cannot straighten her arm. She cannot lift more than 5 pounds on that right side or that right arm. And from little tasks, from her hair to using a fork to everyday normal zippering up her dress, she has limitations.
Even after 7 operations and countless hours of therapy, she was left with severe physical limitations. Simple tasks like doing her hair or eating became difficult, forever changing the way she lives.
I woke up at 2 a.m. and I was headed on into work, going the same way that I always did, when suddenly I saw bright headlights coming right at me. The next thing I knew, I woke up in an emergency room.
When the case went to court, Roland and her family described the lasting impact of Savage's reckless choice, speaking of shattered dreams and daily struggles that no prison term could erase.
Through the grace of God, you did not kill her that day. You killed every dream she ever dreamed. So you see, this was not just a bad crash. This changed her life forever. And forever, she has these scars, missing body parts, and limited use of her right side.
Savage accepted a plea deal and apologized to her family, acknowledging that no sentence could undo what he had done.
I also just wanted to apologize for just any turmoil that I know cannot go away, no matter how long I served or how long she goes on through life. I know it just won't change, and I do apologize for that. So I really just wanted to make that known.
It was definitely a difficult day for me. To see the person that has stolen my life and wrecked my dreams, but I'm very thankful that he took accountability and will be serving.
He was given 3 years in prison and 6 years of probation. Determined to turn her tragedy into action, Roland later stepped away from journalism and now leads Mothers Against Drunk Driving, dedicating her life to educating the public about the consequences of impaired driving and standing up for victims like herself. In March 2023, Patty Peoples and her business partner were preparing to sell their vacant rental home in Jacksonville when 2 women unexpectedly moved in, claiming they'd been scammed by a fake lease. Using a legal loophole, they refused to leave, living in the house rent-free for weeks while Peoples was locked out and forced to fight the situation through the civil court system.
You don't have every right to be in the house at all.
I did, ma'am.
God.
By the time the women were removed, the home was left damaged, with a broken window and other costly repairs waiting for Peoples.
Why did you break the window?
Do it look like we did it on purpose?
Don't say nothing to her. Bye.
Unfortunately, that wasn't me.
That is you in the video. What are you talking about?
Unfortunately, that wasn't, so I don't know what you're talking about.
Peoples said the ordeal caused enormous stress and financial loss.
She created enormous emotional and psychological damage by turning my life upside down, by squatting in my home.
One of the women was later arrested and charged with trespassing and criminal mischief for the damage. In court this summer, she agreed to plead guilty, serve a year on probation, and pay about $3,600 in restitution, though the judge has not yet signed off on the deal and wants more details before sentencing.
I do feel significantly bad because when I did see the damage, it was just like, whoa, wow. And again, that is not me as a person. So I just wanted to let you know again that I do apologize, not to only you, but Miss Patty, for what she has to go through. And that's all I really wanted to say, because I feel like I was being looked at in a bad way, and that's just not me personally. I don't feel as if that I am a criminal.
Patty's long fight didn't just get her property back, it helped change state law. Inspired by her case, Florida lawmakers passed a new anti-squatting law, effective July 1st, 2024, that now lets police remove people squatting in homes without a valid lease immediately, closing the loophole that once kept Patty out of her own house. In late October 2024, 18-year-old Tyreese Earnest allegedly shot a co-worker in the parking lot of the FedEx World Hub in Shelby County, Tennessee. Investigators later described the shooting as a deliberate ambush that left the victim with serious injuries.
I asked if he saw the shooter. He said he did see the shooter, and that information was not disclosed the first time. And I asked why it was not disclosed, and he advised that he did not want to be considered a snitch.
Earnest was arrested and initially held on a $200,000 bond, but was released the following month on his own recognizance, despite prosecutors warning he was a threat. The victim's mother spoke out, describing how her son still struggles to move because doctors cannot safely remove the bullets.
No, they cannot remove the because it's too close to his heart.
In December 2024, at the urging of the district attorney's office, a judge reinstated Earnest's original bond and ordered him back into custody after hearing testimony that a key witness had first withheld information out of fear of being labeled a snitch. Earnest's mother argued her son was following his release conditions and preparing to graduate from high school, but prosecutors said the same support system had failed to prevent the shooting in the first place.
He is gonna do exactly how he's supposed to do and have to do until this is over with. He's gonna be here. Like I say, he wakes me up.
Earnest is now formally indicted on attempted second-degree murder and related charges and remains behind bars awaiting his next court hearing, scheduled for January 14th, 2026. In 2013, Jessica Boyers, a 24-year-old language arts teacher at Highland Middle School in Kentucky, began an unlawful sexual relationship with one of her students. The relationship lasted about 2 months before it came to light, when police found Boyers and the boy together in a parked car at Buccal Park. Once the situation was uncovered, school officials immediately removed her from classroom duties, and she later resigned. Investigators confirmed multiple sexual encounters, leading prosecutors to file charges in both Jefferson and Oldham counties, where Boyers lived at the time. Facing serious accusations, Boyers showed no emotion as she stood in court and pleaded guilty to second-degree rape, second-degree sodomy, and first-degree sexual abuse.
Whenever you have a teacher and there's an allegation of misconduct with a student, those are probably the saddest cases. I think the overall outcome was just a balanced approach on what to do with Ms. Boyers under the circumstances of her case and to set the appropriate punishment.
By admitting guilt in both countries, she avoided trial and received a combined 12-year prison sentence to be served at the same time. Under state rules, she will be eligible for parole after serving just over 2 years. For years, Alon, Orrin, and Tal Alexander, wealthy real estate moguls known for selling luxury homes in Miami and New York, lived lavishly while allegedly hiding a dark pattern of predatory behavior. Beginning as far back as the early 2000s, dozens of women say the brothers used their status, money, and charm to lure them to exclusive parties, only to trap and assault them behind closed doors.
Ma'am, you are being taken into custody for criminal contempt, and you, ma'am, are going to the Wayne County Jail for 93 days for direct criminal contempt. Anybody else want to go? Try it.
One woman described how Orrin raped her at the famous Versace mansion in Miami in 2013, after inviting her to what she believed was a harmless party. Others claim they were invited to private gatherings that turned out to be setups, with no other guests, locked doors, and terrifying assaults that some victims say involved more than one brother at a time.
Amanda, look what you did to my life. You ruined everything I had, like my dad's life.
And you can go too, because if you don't know how to act, you can go to jail. This is a court of law, and these are very serious matters, and I understand you all are upset because your loved one is going to prison, but guess what? She's going to prison for the choices that she made.
In late 2024, after mounting reports and a wave of civil lawsuits, the FBI arrested the brothers on federal charges including sex trafficking, conspiracy, and aggravated sexual abuse. Each has pleaded not guilty, but more women keep coming forward, bringing the number of accusers to over 50. Judges have repeatedly denied bail, calling them a danger and a flight risk. As the case moves forward, the brothers now face both criminal prosecution and multiple civil suits, alleging years of calculated abuse. If convicted, when the trial begins in early 2026, they could spend the rest of their lives in prison. When Gail Mapp first opened a city water bill, demanding more than $81,000 for her vacant Atlanta property, she knew something didn't add up. For years, the crumbling building on Donald Lee Hollowell Parkway sat unused, with no running water and bills averaging about $13 a month. Then, without warning, the city's Department of Watershed Management claimed she'd consumed enough water to fill swimming pools, despite no evidence of a leak. Plumbers she hired found nothing. The city's own inspectors found nothing, yet she was still told to pay, with nowhere else to turn. Mapp decided to fight City Hall, taking her case to court after her appeals were dismissed without explanation.
Any running water in here?
No running water.
Based on this much water usage, the ground of the property likely would have caved in. The property would be almost floating down the street. If there was a leak to that extent, it certainly would have been noticeable. The city would like for everyone to basically leave their common sense at the door to accept its arguments, and apparently the board's custom is to do so in rubber stamping the department's billing error.
Last month, after more than a year of legal back and forth, Fulton County Superior Court Judge Emily Richardson ruled firmly in her favor.
And I see that on December 20th, 2022, 2 days before the register was replaced, it was a normal reading as it had been for the past decade, and suddenly, the next month, it shoots up. And then it stays incredibly high until the register is replaced again in August of 2022.
The judge pointed out that when the city's water meter was swapped out, the huge bills vanished overnight, clear proof the problem was never a hidden pipe, but faulty equipment. She called the city's refusal to fix the bill baseless, rejecting wild claims about stolen water or invisible underground leaks. For now, Mapp no longer has to worry about drowning in a debt she never owed, though the city still has the option to appeal. In May 2014, Felicia Williams was reported missing in Tampa, Florida. She had been left in the care of her babysitter, who briefly stepped out, leaving Felicia alone with the babysitter's boyfriend, Granville Richie. That decision proved tragic. The following day, the girl's body was found near the Courtney Campbell Causeway, concealed. The discovery shocked the community and launched an intense investigation. Suspicion quickly turned to Richie, who was one of the last people seen with Felicia. Evidence began to mount, pointing to his involvement. Over time, detectives gathered witness testimony and forensic evidence linking Richie to the crime. Eventually, he was charged with 3 serious offenses: first-degree murder, battery of a child under 12, and aggravated child abuse. In 2019, Granville Richie stood trial. Jurors listened to days of emotional testimony and reviewed the state's evidence. After deliberating, the jury unanimously found Richie guilty on all counts and recommended the death penalty for the murder charge. 1 year later, in September 2020, Judge Michelle Sisko delivered the final sentence. She affirmed the jury's verdict, stating that the aggravating factors in the case significantly outweighed any arguments made in Richie's defense.
In the instant case, the jury unanimously found that each of the aggravating factors presented by the state were proven beyond a reasonable doubt, and that the aggravating factors outweighed the mitigating circumstances presented by defendant. The jury unanimously found that defendant should be sentenced to death. As such, the court has now conducted its own weighing process as required by law. Mr. Richie, I need you to stand and please approach the podium. Mr. Richie, the court has thoroughly reviewed and considered the record concerning defendant's trial, including both the guilty and penalty proceedings, as well as the memoranda submitted by both the state and the defense. The court has also evaluated and weighed the aggravating factors the jury has found to exist beyond a reasonable doubt, and the mitigating circumstances established by the evidence. The court acknowledges that this weighing is not a quantitative comparison, but instead requires a qualitative analysis of each aggravating factor and each mitigating circumstance. The court has assigned an appropriate weight to each and finds that the aggravating factors found to exist heavily outweigh the mitigating circumstances presented. The court finds that the jury's recommendation to impose a death sentence is consistent with its verdict and is based on the evidence presented regarding the aggravating and mitigating circumstances. The court agrees with the jury's unanimous recommendation based on its own assessment of the aggravating factors weighed against the mitigating circumstances. The court finds that the aggravating factors substantially outweigh the mitigating circumstances and sufficiently warrant a sentence of death in this case. Therefore, the court finds that the sentence of death is the appropriate penalty the court should impose for the murder of 9-year-old Felicia Williams, as charged in count 1 of the indictment. Accordingly, as to count 1, for the first-degree murder of Felicia Williams, the defendant, Granville Richie, is hereby sentenced to death. Defendant shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison, where he shall be confined until a date certain, selected by the governor of the state of Florida, and on that date, defendant shall be executed in a method provided for by the laws of the state of Florida. As to count 2, for the sexual battery of a victim less than 20 years of age by a defendant over the age of 18 committed against 9-year-old Felicia Williams, defendant shall be sentenced to life in prison without the possibility of parole. As to count 3, for the aggravated child abuse of Felicia Williams, defendant shall be sentenced to 30 years imprisonment. Counts 1, 2, and 3 shall run consecutively to each other. However, the 2 cases you pled to earlier today will run concurrent with count 1. Defendant is hereby notified that this sentence is subject to automatic review by the Supreme Court of Florida. Counsel will be appointed by separate order to represent defendant for that purpose. Further, pursuant to section 922.105 Florida statutes, defendant has 30 days from the issuance of a mandate from the Supreme Court of Florida affirming the sentence of death to elect by electrocution by the procedures required by law. Mr. Richie, I do have one final thing to say to you. There will be no corporal redemption for you. And what I mean by that is of your physical being, your person. You will remain incarcerated until the date of your death is scheduled to occur. However, I do not know what your spiritual leanings are, and it really does not matter to me either way. I am very grateful that I live in a country where people can believe or disbelieve anything they choose, and that applies to you equally. However, if you do ever pray to a higher power, either now or at some point before the date of your death is scheduled to occur, and you truly seek forgiveness and redemption for the sins and the crimes you have committed, I hope that you are granted it. And I do still see the humanity in you. May God have mercy on your soul, Mr. Richie.
Judge Sisko sentenced Granville Richie to death for the murder of Felicia Williams. In addition, he received life in prison without the possibility of parole for the sexual battery charge and a 30-year sentence for aggravated child abuse. These sentences were ordered to run consecutively. The sentencing ended with a gesture from Felicia's family. They had sent a sealed card containing a Bible verse and a photo of Felicia, affectionately known as Sugar Plum.
We are now concluded, other than I am going to read the note that I received that was unsealed, or that was sealed. I'm now going to unseal it. And it is a card, and it says, "I thank God as I remember you." 2 Timothy 1:3, and it's from the family of Felicia Williams, and it's a photograph of Felicia, aka Sugar Plum. And I wish to thank you all for this. God bless all of you. Thank you very much. We're now concluded.
The judge unsealed the card in court and thanked the family for their strength and grace. In 2022, the Florida Supreme Court upheld Richie's conviction and death sentence, confirming the trial court's decision. Letha Slawson's case began in late 2013 when she started claiming that her daughter Riley had terminal cancer, out of what she described as desperation and fear after receiving no clear medical answers. Slawson took matters into her own hands, administering non-prescribed treatments while also launching public fundraisers to cover what she framed as mounting medical expenses. The story captured widespread sympathy, and the community rallied around Riley, organizing events, raising money, and even helping fulfill a bucket list. But in August 2014, the deception unraveled when authorities discovered that Riley had never been diagnosed with cancer. Slawson was arrested and charged with numerous felonies, including endangerment and the unlawful administration of drugs. In September 2014, she pleaded not guilty, and prosecutors warned that she posed an ongoing risk to the public. However, in November, she accepted a plea deal, admitting guilt to 5 of the charges. During court proceedings, Slawson was diagnosed with a psychotic disorder marked by hallucinations and delusions.
The judge agreed that prison wouldn't give Slawson the help she needs, but she wanted the mother to forever be marked with a scarlet letter, felony convictions for 2 counts of endangerment.
At sentencing, Slawson delivered an emotional statement to the court, expressing deep remorse and describing how she had felt alone, unsupported, and overwhelmed by the pressure of motherhood and unanswered medical concerns.
It is even more repugnant.
Judge Kilnosky sentenced Slawson to 10 years in prison, but set the sentence aside, opting for 5 years of probation.
She said she never intended to harm anyone, and that everything she did was driven by love and a desire to help Riley. Slawson detailed how mental health treatment had helped her regain clarity and control, and she acknowledged the pain she caused her family, the community, and those who supported her. Though she admitted her Austin Chronister, a Milwaukee realtor, is facing serious criminal actions were wrong. She pleaded for understanding and hoped one day to make amends with those she had hurt.
Your Honor, is the microphone on up there?
I don't know whether it's...
Letha, you'll have to speak up too, okay? The court reporter needs to take down what you're saying.
I wrote this letter. I can write you a book, but you don't know me. I could write you a book, but you don't know me. You only know me by all the stories, some true and some false. But you will believe what you want. I could tell you I was a hospital clown and gave presents to kids and their parents. I could tell you all the charity work I did. But I just want you to know this is from a mother and wife's loving heart that just wants to get better. First, I want to say I am so sorry for all of this. I thought Riley was sick and like any mother tried to care for her. Doctors were not doing anything to help. I was scared and wasn't not getting any answers. I was going from doctor to doctor to find out what was wrong. So I finally took it in my own hands to make her better. I just wanted her to feel better and eat good and be healthy. I was so happy to know someone finally checked Riley out and she was cancer-free. I finally got someone to listen. That is all I wanted. Now I want to be healthy so I can be a good mother and wife. That's why I am following through with my therapist appointments and my meds. I want to still be a mother to all my beautiful babies, just a better one. What I am confused about is why are my kids afraid of me now that I'm away from them? I know that I need to fix myself. I did this out of love, not for money. But I hurt so many people. I never meant to do this. I turned their love to hate. I turned their smiles to tears. I hate that I did this. I don't blame anyone but myself, but I do question, where was John when I was hurting? Where was John when I stayed up all night crying? Where was John when I needed help? I just wanted him to listen, to hear me, to love me, to care for me. I felt like he was pulling away. Sorry. I have 5 children to care for. therapy appointments to go to, teacher appointments, meals to cook, and household chores to do, and so much more. I could not do this all by myself. Now I am so broken. I would give anything to be back with him in my life. It keeps me every day waking up and not being with my babies. Hearing their little voices, feeling their hugs. I could most likely lose custody of my 5 beautiful babies. It's the worst punishment of all. It breaks my heart not to be with my children. It hurts so bad to hear the anger and sadness from John. I never meant to hurt them or anyone. I had been a stay-at-home mother for 12 years, and John being a full-time working dad. John was a very hard-working dad. We were a team. All the child care and household stuff was done by me, but I was seeking help at times, and it hurt. I had no free time or adult interaction. I just want to be a mother to my son, Jaden. He tugs at my heart every day with his big hugs and love, and his cooking talents are delicious. My daughter, Ellie, that tugs at my heart every day with her kindness and beauty. She is my mini-me. My daughter, Riley, that tugs at my heart every day with her big hugs. She's my spunky little artist. My daughter, Faith, that tugs at my heart every day, wanting to be my buddy, my Minnie Mouse princess buddy. My son, Cole, that tugs at my heart every day with his sweet baby face and baby cuddles, and his sweet voice. All my children mean the world to me, and I would do anything for them. As for the cystic fibrosis, John was in the appointment when the girls got diagnosed in Fort Dodge. And he was in the appointment in Des Moines when Faith and Riley got retested. And we were told they did not have CF, but really bad asthma, and Riley had severe stomach issues. I have always been there for my kids. For school stuff, school activity, playing games, therapy, hospital stays, and when they needed to talk. I did it all. When Riley got sick, I was lost and confused, because doctors and John were not there to help me. I felt alone in this huge fight to find out what was wrong with her. I am so sorry it got this far. I never meant to hurt anyone. In the end, it was so hard to say no. So many people did so much work, and I felt like I would be letting them down. The fundraisers, the events, another caring person that opened an account for monies, and a bucket list that was put together for Riley. I did not ask it, but I love seeing my kids happy and having so many wonderful people show me they cared. I'm starting to feel like a new person. I went from hearing voices and seeing things, anger and sadness all the time, to learning to be normal. I still need work, but I am working on it a little every day. At first I was so scared when I started the meds, and nothing was working right away. Then the voices stopped, the vision stopped. I was so scared at first, but then it was nice. I could function, it was quiet. Now it was finally out. I felt like a weight was off my shoulders. I finally found out some of what was wrong with me, and there was a med to help. But the pain I caused my family by keeping that to myself is more than I could ever imagine. But how do you tell someone you hear voices? How do you tell you to do things and see shadow people? How do you get people to understand that? It seems so much easier to cope with it, to live my life fighting with myself.
In January 2015, the judge sentenced her to 5 years of probation rather than prison, citing her mental illness and commitment to ongoing treatment. As part of the sentence, she was barred from having contact with her daughters and sons and required to continue therapy. Austin Chronister, a Milwaukee realtor, is facing serious criminal charges in 2 separate cases, both involving accusations of human trafficking, coercion, and misconduct. The allegations began surfacing in early 2025 when several women reported disturbing experiences connected to Chronister's residence, referred to by some as House St. Pierre. According to their accounts, they were lured into what they believed were consensual relationships, but soon found themselves trapped in a system of control. Some described being pressured to sign obedience agreements and being assigned identification numbers. Others claimed they were manipulated into staying through fear, emotional pressure, and restrictive conditions. In May 2025, police confirmed they had launched a formal investigation, recovering digital materials and videos from Chronister's devices. The charges filed against him included human trafficking, second-degree sexual assault, and false imprisonment. Prosecutors argued that Chronister maintained control over his victims by harboring them and using implied threats rather than outright violence. During court proceedings, it was revealed that an attorney, Kristen St. Pierre, may have had some involvement in the situation, though she has not been formally charged.
State of Wisconsin versus Austin Chronister, case number 25 CF 1231 and 25 CF 2138. Appearances, please.
Ken Olsztynski for the state.
And good morning, Your Honor. Attorney Nicole Muller appearing for and with the defendant, Mr. Austin Chronister.
Okay, so there's a motion as far as a bill of particulars, is that correct?
That is correct.
Which no longer exists under Wisconsin Rules of Civil Procedure, and the procedure is no longer available in criminal proceedings. Court's going to deny the motion.
If the court's going to deny the motion under that grounds, which actually the case law says it's still under the court's authority, but I guess the court's authority is to deny it, then I'd ask the court to order the state to tell us what specific...
They don't have to do that. So I don't understand. They have to explain their case to yourself?
Judge, this is a situation where they keep sending more and more and more in discovery. We had the exclusion order because they kept adding charges, decreasing charges. The trafficking charges that they have charged with, they did not establish in the criminal complaint what specific element of the trafficking count that they are proceeding on, whether it's harboring, whether it's forcing, whether it's enticing, all of those
things. That answer right now.
That's what I'm looking for.
Generally, it was harboring.
Pardon?
Generally, it was harboring.
Not generally. What is it?
Well, I have 4 different victims, for starters, so each one is a little different. He harbored each of them. Several of them in the charging information does delineate exactly the manner in which he used either force or coercion. I can go by count, but it says it specifically in the information. For count 1 in the case ending 1231, it reads in the information, by causing or threatening to cause bodily harm to any individual. For count, and that was the first case, one moment.
Well, if we could just stick on count by count, you're still saying by force, but what I need to know is that was it recruiting by force, enticing by force, harboring by force, transporting by force, providing to furnish by force, obtaining by force?
Harboring.
Pardon?
Harboring.
Okay. So do we have a further date on this?
We don't at this time, so I just want to be very clear that for each of the trafficking counts, that it's the gerund is harboring.
Yes, that's my understanding. After a brief glance at this right now, I believe it to be harboring. I believe that's what I charged under. However, the causing or threatening to cause bodily harm to any individual, I believe, does change in the second case for the final count, count 6. That was done under trafficking done by any scheme or pattern or other means to directly or indirectly coerce, threaten, or intimidate any individual.
Okay, so what do we need, a pretrial date and a trial date?
I believe we can set that, Your Honor. I do have one thing. Last time we were here, I asked for clarification on one of the court's orders. Your Honor, this case had an arraignment date and a prelim date on the latest charged case.
Okay.
Your Honor told me to make sure I got all of the discovery to the defense by May 23rd. Otherwise, the defense could file a motion. The defense filed a motion and a proposed order to exclude all discovery after May 23rd. However, we continued to do investigation after May 23rd. We discovered additional information, and as counsel indicated, we've been turning over information as well as we've been getting it.
So all of that's been turned over?
I believe all that's been turned over, but we've still continued to do an additional interview that I know that counsel is most likely aware of at this point in time. One of the interviews was actually just completed yesterday. So we do have stuff trickling in, but I wanted clarification as far as these materials that we're now obtaining. Is the court going to exclude any and all discovery after May 23rd, or are we allowed to continue to turn over materials as we get them to use them for trial?
Second.
Thank
Well,
you.
Judge, then, but what's the deadline? Because what are we going to have the day before trial and they're
No,
still giving me
I'm
stuff?
going to do that. Okay? But please don't speak over me, all right? When is all the discovery, or is it already been completed?
It has been substantially turned over, and I understand, obviously, if we run into a trial date and we're not able to access a phone due to either if there's a warrant status or one of the phones is currently trying to be accessed but can't, obviously it's excluded. We'll do everything we can to try to get that beforehand, but there's certain materials that we are attempting to either obtain a warrant on or obtain consent on to search. But by and large, I believe we have a substantial amount of it already done. But it's a lot of digital media that I anticipate that will be turned over. I think if the court were to give me until a final pretrial date and trial date, we could generally make sure that we get a substantial amount of it over, and I could probably inform the court if there's one or two things hanging out that we know what it is. But for the most part, we have a lot of it turned over. There's just a handful of things here and there that I know are still in the wind.
Judge,
There's a handful of here, there.
Yes.
It's not going to work for the defense.
I understand.
So they need the complete discovery,
If I may,
whatever you're going to be using.
Of course.
if I may, Judge, I just find the state's argument here today disingenuous because when we were in court, when the court made the order for the May 24th deadline, the state gave the same story. Our investigation is ongoing and we're still getting information. And that's why Your Honor said, well, when will you be done with your investigation? And the state said, please give us this time. You said, okay. You set the deadline. And now they're coming back saying, well, we're doing more investigation. And so it's not appropriate. We need more time. And they were given the time. This court allotted them. If they want to continue an investigation, then they should not have charged Mr. Chronister. They should have waited till their investigation was complete, so then all of the discovery would have been handed over right away, and we would be able to prepare a defense.
Thank you. I understand what you're saying.
As the case progressed, the defense raised concerns about the changing scope of allegations and late discovery submissions from the prosecution. In response, the court issued a firm deadline of August 25th, 2025, by which all relevant evidence had to be shared. Anything submitted after that date would not be allowed at trial unless it clearly supported the defense. The court also clarified that the trafficking charges were primarily based on harboring through coercion or threats rather than recruitment or transportation. To avoid confusion or last-minute shifts in legal strategy, the judge ordered the prosecution to confirm the exact nature of each trafficking count by the discovery deadline. A joint motion hearing and final pretrial conference was scheduled for November 6, 2025. The jury trial for both cases was set for January 26, 2026. On the evening of September 22, 2024, Michelle Luna Jackson left her home in Farnhamville, Iowa, riding her mother's green electric scooter. It was a familiar routine, visiting a nearby park where she enjoyed listening to music while using the swing set. Tragically, she never returned home. When Michelle missed her 10 p.m. check-in, her mother, Annette Jackson, became concerned. She called Michelle's sister, Shauna Bachman, and the two began searching the neighborhood. During their search, they encountered Nathaniel Bevers-McGivney, Bevers-McGivney riding Michelle's scooter. He gave conflicting stories about why he had it. The distinctive basket and blue bungee cord on the scooter confirmed to Annette that it belonged to her daughter. Moments later, she noticed one of Michelle's shoes in the basket with what appeared to be blood on it. She immediately called 911. While waiting for the police, Shauna contacted her boyfriend, Jordan Adams, who arrived at the scene. Concerned, he held Nathaniel in place until Deputy Jason McKenna arrived. When authorities reached the location, they observed that Nathaniel had visible stains on his clothes and hands. He was detained for questioning. The next morning, a local employee at Landis Cooperative made a disturbing discovery. He found a trash bin left near a cornfield, and, upon looking inside, discovered a body. Law enforcement identified the remains as Michelle Jackson. A search of the nearby park revealed signs of a struggle, as well as items like earbuds and a scooter key. A trail of markings led investigators to believe her body had been moved from the park. Authorities quickly obtained search warrants for Nathaniel's apartment and personal belongings. Inside, they found several indicators linking him to the case: blood evidence on floors and towels, and a handle matching forensic samples. He also had visible injuries to his hands. DNA tests later confirmed that traces from the scene and his residence matched both Nathaniel and Michelle. Nathaniel was formally charged in October 2024 with first-degree murder and abuse of a corpse, to which he pleaded not guilty. He opted for a bench trial, waiving his right to a jury.
On September 22, 2024, Michelle Jackson used her mother's green electric scooter to travel from her residence to Farnhamville City Park to use the swing set. Michelle had an established habit of traveling via electric scooter to the same park to ride the same squeaky swing while listening to music. The defendant arrived at the park with a knife that utilized 3 different interchangeable blades that is commonly used for hunting and gutting animals. The defendant cut Michelle with the knife and stabbed her multiple times, resulting in her death. During the assault, the defendant received multiple cuts and lacerations to his own hand. He then dragged her body a short distance. The defendant returned to his apartment, where he placed the knife handle covered in Michelle's hair in a garbage can located in his apartment. The defendant left blood in his apartment, on the floors, on the bathtub, and on a white towel. The defendant left his apartment and then located and retrieved a nearby rolling trash bin and placed Michelle's body in it. He then rolled the trash bin a significant distance away from the park and left it by a nearby cornfield. Afterwards, he returned to the park and retrieved the scooter. At some point, the defendant placed one of Michelle's shoes in the back basket of the scooter that also had a blue bungee cord attached. When Michelle did not timely return to her mother, Annette's house, by 10 o'clock p.m., Annette became concerned and telephoned her older daughter, Michelle's sister, Shauna Bachman. Shauna made a loop around the park, and after finding no signs of her sister, went and picked up Annette. The 2 women continued searching and discovered the defendant in possession of the green electric scooter. The defendant gave conflicting explanations for why he was riding the scooter. Annette recognized that the scooter was her daughter's by the basket and blue bungee cord on the back. Annette called 911, and Deputy Jason McKinney was dispatched. Although he was approximately 20 miles away and did not arrive for some time. In the meantime, Shauna had called her boyfriend, Jordan Adams, who arrived at the scene with a firearm and began questioning the defendant. Soon after Jordan's arrival, Annette inspected the scooter and noticed one of Michelle's shoes was in the basket and had blood on it. Jordan then aimed his gun at the defendant and ordered him to lay on the ground. Jordan held the defendant on the ground at gunpoint until the police arrived. When Deputy McKinney arrived, he turned his white lights on to illuminate the scene. He ordered Jordan to put down his firearm and to move away. He ordered the defendant to stand up, at which point everyone on the scene realized that the defendant was covered in blood. He was promptly detained. The next morning, Austin Ehrig, an employee at Landis Cooperative, noticed a rolling trash bin in an unusual location at Landis Cooperative. He opened the trash can and ultimately determined that there was a body inside. He contacted law enforcement, and they retrieved the body. Law enforcement investigated Farnhamville City Park and discovered several large pools of blood, 2 earbuds, and what appeared to be the key to an electric scooter near or in the pools of blood, and drops of blood photographs that would suggest a body had been drugged. The police obtained search warrants for the defendant's apartment and the defendant's body. At the defendant's apartment, they discovered the knife handle in the garbage that was matted with blood and hair, as well as blood spots on the floors, bathtub, and a towel. On the defendant's person, they found a number of cuts and lacerations. In his pockets, they located extra blades and a separate folding knife. An autopsy was performed on Michelle. The autopsy revealed that Michelle suffered a large incision to her neck, 4 wounds to her head, 22 wounds to her chest and abdomen, multiple superficial wounds to her head, arms, and torso, and other contusions. The autopsy did not find that Michelle received any defensive wounds. Michelle's cause of death was deemed to be multiple sharp force injuries. Her manner of death was found to be homicide. Multiple blood samples were tested by the Iowa Division of Criminal Investigation, DCI. These tests showed that the red stains found on the defendant's shirt were blood and that the blood matched the DNA profile of Michelle. Tests of the white towel located at the defendant's residence showed that 3 of the stains were blood that contained a mixture of 2 DNA contributors. The defendant and Michelle were found to be contributors to this mixture of DNA. The blood on the blade handle in the garbage was also tested, and that matched the DNA profile of Michelle.
During the July 2025 trial, prosecutors laid out the evidence in full. The defense acknowledged the incident but argued for a lesser charge, claiming the act wasn't pre-planned. The judge, however, found the evidence showed intent and preparation.
Conclusions of law. The elements of count 1, murder in the first degree as applies to these facts, are as follows. 1. On or about the 22nd day of September 2024 in Calhoun County, Iowa, the defendant cut the throat and stabbed Michelle Jackson. 2. Michelle Jackson as a result of being stabbed. 3. The defendant acted with malice aforethought. 4. Defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill Michelle Jackson. The elements of count 2, abuse of a corpse, as applied to this facts, are as follows. 1. On or about the 22nd day of September 2024 in Calhoun County, Iowa, the defendant either hid the corpse of Michelle Jackson or failed to disclose the known location of Michelle Jackson's corpse. 2. The defendant did so with the intent to conceal a crime. The state has the burden of proof with respect to this case. The legal standard is by proof beyond a reasonable doubt. On September 22nd, 2024, the defendant went to Farnhamville City Park armed with a knife. The defendant approached Michelle Jackson and cut her throat with a knife and then proceeded to stab her in the back until the blade became detached and remained lodged in her back. The defendant then continued to stab Michelle with the handle and base of the knife. Prior to cutting the throat of Michelle, the defendant had the opportunity to deliberate on his decision, and his ultimate decision was to attack Michelle with a specific intent to kill her. The defendant's attack was premeditated, willful, and designed to do physical harm to Michelle Jackson. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of count 1, murder in the first degree. Regarding count 2, the court finds beyond a reasonable doubt that on or about September 22nd, 2024, in Calhoun County, Iowa, the defendant hid Michelle. The evidence established that the defendant dragged Michelle's body through the park, then retrieved a rolling trash bin, put her body in the trash bin, moved the bin a significant distance from the park, and left the bin near a cornfield. The court is convinced beyond a reasonable doubt the defendant hid the corpse of Michelle with the specific intent of concealing the crime of murder in the first degree. The evidence demonstrated that the defendant attempted to move the corpse soon after the and attempted 2 different methods of moving the body, dragging the body and placing the body in a rolling trash bin to move it more easily. This duality of methods of moving the bodies, as well as the significant distance the defendant ultimately moved the body, demonstrates his specific intent to conceal his crime. After considering all the evidence submitted in this case, the court is convinced the defendant is guilty beyond a reasonable doubt of the offense of count 2, abuse of a corpse. Verdict in order. The defendant is found guilty of count 1, murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2, Sub 1, Sub A, and count 2, abuse of a corpse, a Class C felony in violation of Iowa Code Section 708.14 sub 1 sub B. It is ordered that sentencing is set for August 15, 2025 at 10 o'clock a.m. in the District Courtroom of the Calhoun County Courthouse in Rockwell City, Iowa. The defendant shall be held without bond.
On July 10, 2025, Judge Derek Johnson delivered the verdict, guilty on both counts. The court found that Nathaniel had not only caused Michelle's death, but had taken deliberate steps to conceal it afterward. His actions were ruled to be intentional and premeditated. Sentencing is scheduled for August 15, 2025 in Rockwell City, Iowa. Until then, Nathaniel Bevers-McGivney remains in custody without bond. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.